Bella, for the introduction, and it's really great to hear about all the work that your organisation is doing. It sounds fantastically impactful. I'd like to thank you on behalf of the Refugee Law Initiative at University of London for this invitation to present and discuss our recent declaration on international protection in the context of disasters and climate change. So I trust that everybody who's joined has seen a copy of the declaration and the background paper, which are both freely available on the RLI website and through the International Journal of Refugee Law. And I think links to both of those documents will be posted shortly in the chat as well. So why are we speaking about disasters, climate change, and international protection? Well, it's well known that disasters linked to natural hazards can be a push factor for displacement. For instance, sudden onset disasters linked to natural hazards, such as storms, flooding, volcanic eruptions, and wildfires, are known to have triggered an estimated 300 million or more incidents of internal displacement between 2009 and 2022 worldwide. Meanwhile, slow onset disasters such as drought and desertification have also added significantly to human mobility trends. And unchecked global climate change is likely only to exacerbate these trends. In tandem, though, the risks of harm that people face as a result of disasters and climate change in their home countries are also increasingly being raised in claims for asylum or international protection. But among lawyers, decision makers, and policymakers, considerable confusion still persists as to whether persons facing these kinds of risks are in fact eligible for international protection, whether as refugees or under human rights law. Next slide, please. Against this backdrop, the new RLI declaration seeks to offer accessible and practical interpretative guidance on this point. It draws on the input of a wide range of experts within the extensive research affiliate network hosted at the RLI, particularly those who specialize directly on displacement in the context of disasters and climate change. And you can see on your screen the range of people who've been involved in drafting this declaration. Next slide, please. In today's session, I'm going to briefly present some of the key points from the declaration as they relate to the three conceptual and legal questions that you can see on the screen at the moment. Afterwards, there should be plenty of time for discussion and exchange on the themes addressed by the declaration. I hope to be speaking for something in the region of about half an hour, and I apologize for having a cold. I hope you can still hear and understand me well. Next slide, please. So thinking about the conceptual approach, there really are three main conceptual challenges that we identify for practitioners such as yourselves. The first conceptual challenge relates to how we can understand disasters and climate change within the specific context of a claim for asylum. We think that this is fundamentally a conceptual challenge rather than a legal one, because without a proper understanding of this issue, it's impossible to deal appropriately with the legal aspects of claims in this area. In this regard, it's important to recall that refugee status determination is concerned primarily with what? With the risk of harm to a claimant on return to their own country. As such, we need to go beyond commonly bandied around labels like climate change refugees and instead look empirically at the specific kinds of risks of harm that disaster contexts can produce for applicants. Next slide, please. The RLI declaration treats this question as primarily a factual matter. As such, it identifies 5 common scenarios in which a risk of harm may arise in disaster contexts. We're not saying that these are the only scenarios, nor are we saying that somebody facing one of these scenarios is automatically a refugee. But the key point is that the risk of harm can arise not only from the manifestation of a natural hazard like a storm or earthquake. Rather, as you can see from the scenarios described in points 1 to 4 on the screen, there are various other potential sources of harm in disaster contexts that need also to be carefully considered. And a strong element of human agency is apparent in all 5 of these scenarios. Moreover, even for scenario 5, where the risk of harm derives from the manifestation of a hazard, such as a storm or earthquake, it's important, we think, to recognize that the risk of harm is also here crucially shaped by societal or human factors. These influence the extent to which people are exposed to the hazard, how vulnerable they are to its effects, and whether they can manage those dangers. For example, the fact that in 2010, a 7.0 magnitude earthquake in Haiti killed over 200,000 people, whilst an earthquake 500 times more powerful in Chile killed fewer than 600 people, is due primarily to human factors relating to different levels of disaster preparedness and response within those societies. So a key point here is that all of the risks of harm in the 5 scenarios that you see on the screen, including scenario 5, are, to a greater or lesser degree, directly influenced by human factors. In other words, they're not purely caused by natural factors. And this has important implications for applying international protection rules. Next slide, please. The second conceptual challenge that we identify is evident in the tendency to treat disaster-related risks of harm as if they were distinct from risks of harm from other sources, such as conflict and political violence. But the risks deriving from these other sources often interact with and even heighten the risks deriving specifically from those scenarios that we identified in the disaster context. And this emphasizes the importance for international protection of taking a cumulative approach in cases where these intersecting risks of harm result from various sources. In other words, it's important not to treat disaster-related sources separately from those that result from conflict or political violence. A third conceptual challenge in relation to these kinds of cases is to understand how climate change enters into this analysis. Thus far, we've talked about hazards and disasters, but in essence, over longer time periods, climate change serves to shape the risks that are posed by these more proximate, these closer sources of harm. For example, climate change can act as a threat multiplier, making climate-related hazards such as storms more frequent, intense, or unpredictable over the longer term. Equally, the effects of climate change may reduce the capacities of a society to respond to the risks posed by such hazards, for example, by weakening the institutions and infrastructure necessary for protection due to repeated hazards and disasters. So for the purposes of international protection then, climate change can be treated as a factor, a background factor, if you like, that over time shapes the likelihood of a disaster occurring and shapes its severity, rather than a standalone source of harm in its own right. So with this firmer understanding of how disasters and climate change can generate risks of harm to people, we can now turn to see how the law applies to these situations. And in talking about the law, my assumption is that everybody on the call is familiar with the basic refugee law definition and basic understandings of refugee law. Next slide, please. So if we turn to the legal approach, it's important at the outset to recognize that alongside refugee and human rights law, there exist a range of other national and international legal and policy frameworks which are potentially relevant to the admission and stay of people who are fleeing a country affected by a disaster. Indeed, the international protection regime will often not be the principal framework for resolving the entry and stay of people fleeing from a country affected by disasters. Rather, broader migration frameworks at the regional and national level are highly relevant to this issue. One implication of this is that keeping existing lawful migration routes and options open for people from disaster-affected countries is as important as thinking about the application of international protection law to such cases. Nonetheless, having said all of that, in practice, international protection frameworks in refugee law and human rights law may still come into play in these sorts of cases. This is most likely to be the case where a person outside their country for disaster-related reasons is unable to avail themselves of one of the other migration-based options in this wider toolbox of legal and policy responses, and where the disaster-related risks of harm to the person in the country of origin are sufficiently serious to call questions of international protection into play. So how then does international protection law apply to these kinds of cases? Well, in determining disaster-related cases under international protection law, the Declaration identifies two key overarching principles. The first of those is, as with any other refugee case, each claim must be assessed on its own facts. In other words, the existence of a disaster doesn't always mean that there's a need for international protection, but also it doesn't mean automatically that international protection needs can never arise in disaster contexts, as some of the early refugee law judgments have wrongly suggested, saying that, for example, the refugee definition doesn't apply to questions of poverty, disasters, and so on. Instead, what we say is that what is needed is a careful review of the facts of the situation to identify actual risks of harm, regardless of the source of the harm, and to evaluate cumulatively whether those risks of harm engage international protection rules. The second key point is that no new or special rules apply to disaster-related cases. This may seem obvious, but ordinary legal principles and evidential rules of refugee status determination apply unchanged. There's no need to start importing definitions from disaster response law or to determine whether a situation in country of origin meets the threshold for being considered a disaster under the relevant disaster frameworks. The only change in relation to these kinds of cases is that some of the sources of country of origin evidence relating to the risks arising in disaster contexts may be new and unfamiliar to decision makers. And we can talk a little bit more about what that evidence might be in the discussion section. But let's see now, how do these principles play out in relation to the Refugee Convention definition? Next slide, please. So as a starting point, it's really important to emphasize that in applying refugee law to these cases, there's no need to try and use confusing and non-legal terms such as climate refugees or disaster refugees. They have no relevance or purchase here. What's needed is just to continue to apply the standard Article 1A2 refugee definition to the facts. So how does this play out in relation to disaster-related cases? Well, let's think through the elements of that definition. Let's start with the Article 1A2 element of being persecuted. As you all know, you have to show a well-founded fear of being persecuted in order to engage the Refugee Convention. Now, it's evident that the kinds of intentional infliction of harm identified in scenarios 1 to 4 can easily qualify as persecution, so long as the harm is serious enough. For example, if somebody is being detained by their government because they've been protesting about climate issues, that kind of harm may well qualify as persecution. It's intentionally inflicted. Scenario 5 is more complex. Scenario 5 is where there is exposure to a natural hazard. And in this case, I think it's difficult to say that a natural hazard, a storm, flooding, etc., is in itself persecutory. Nonetheless, the Declaration makes the point that it's important to bear in mind that the fact that a person is exposed to that hazard and vulnerable to its effects might actually be due to discriminatory practices by the state or by wider society. And in those cases, the situation of harm might potentially be characterized as persecutory if the harm is serious enough. Conversely, this may not be the case, for example, where exposure and vulnerability were the result of other factors, things that are not based on discriminatory practices. That could be structural disadvantage, poverty, and such like. Moreover, in the disaster context, as in any other context where you're determining refugee status, the severity threshold for persecution should always be assessed cumulatively. And this speaks to the earlier point about the need to look at different sources of risks together rather than separating them off. For instance, the everyday serious forms of discriminatory ill treatment faced by a member of a marginalized minority ethnic group must be considered cumulatively, along with their exposure or vulnerability to the effects of natural hazards due to such discrimination. For example, they may be pushed to live in areas that are particularly exposed to flooding, or where disaster relief doesn't arrive when there is a tsunami, for example. So all of those things must be considered together cumulatively in determining whether the severity threshold for persecution is met in that context. Turning to the reasons for persecution, in disaster settings, it's evident that the human element of the harms in scenarios 1 to 5 will often be for reasons recognized by the Refugee Convention. For example, holding back disaster relief from political opponents or from despised ethnic minorities is likely to engage established convention grounds in the same way as detaining them for those reasons. Equally, a government's disaster response and climate change policy are in themselves often highly political issues relating directly to the functioning of that state. As such, we make the point that activism or criticism around disaster response and climate change issues is quite likely in many societies to engage the convention ground of political opinion, or to be perceived by persecutors as expressing a political opinion. I think a more complex issue in this case, in these sorts of disaster-related cases, is how to evaluate well-founded fear, i.e. the well-founded fear of persecution, particularly in cases where the purported harm lies further into the future. What I'm thinking of here is, for example, the scenario 5 cases of natural hazards, where the feared disasters aren't sudden onset, but are instead slow onset over time. And this may include those that are linked to the effects of climate change. Now, some courts have suggested that these kinds of harms in these slow onset scenarios can show a well-founded fear only where the harms are, quotes, imminent. In other words, they're fairly close in temporal terms. But the RLI takes the view that there's no requirement legally in the Refugee Convention that the risk must be temporally imminent in order for it to be, quotes, well-founded. There's nothing in the Refugee Convention that says a well-founded imminent risk of persecution. It merely says that the risk of persecution must, or the fear of persecution must be well-founded. As such, in the declaration, we take a different view, and we suggest that time operates more as a sliding scale as to the strength of evidence that's required to show that a fear is well-founded. So the further into the future the feared scenario of likely harm lies, the more compelling the evidence will need to be of the reasonable likelihood of its occurrence and the absence of potential mitigating factors, for example, a change of government, an improvement in disaster prevention and relief, and so on. Moreover, given that many natural hazards are by nature recurrent, seasonal, or even worsening in the context of climate change, we take the view that decision makers should be hesitant to find that a fear of these kind of hazards recurring is not well-founded. Finally, then, when assessing protection as another element of the refugee definition, we consider that it's crucial for decision makers to assess whether the protection is not just generally sufficient, but that it will in fact address the risk of the particular kind of harm feared. So decision makers in this area are used to considering protection in terms of national protection mechanisms for mitigating the risk of harm from human actors. We're talking here about the police, the judiciary, and so on. But in disaster contexts, they're going to have to consider other kinds of protection mechanisms where the risk is posed, particularly in scenario 5, by a natural hazard. And those other kinds of protection mechanisms include disaster risk management, climate change adaptation, and sustainable development mechanisms for addressing that kind of disaster risk. So they're going to need to look more broadly in thinking about what kind of protection is available, but they're also going to have to make sure that that protection is sufficient in relation to the particular kinds of harm that they're considering. Conversely, though, disaster-related risks of harm and the availability of protection should be routinely considered in evaluating whether an internal relocation alternative exists elsewhere in the country, regardless of whether the risk in the home area was originally disaster-related or not. In other words, disaster-related risks are always going to be relevant to internal relocation and whether or not that is reasonable, and so on. Next slide, please. So I'd like to end by briefly addressing some of the other frameworks that exist for international protection. Firstly, it's well established that complementary international protection, i.e. complementary to refugee law, can take place under the non-refoulement provisions of human rights law, including that as codified under the subsidiary protection provisions of the EU Qualification Directive in Europe. Crucially, most of the rights underpinning these non-refoulement rules in human rights law can be violated not only by harms emanating from human sources, but also by those deriving from natural sources too. And in this regard, the RLI Declaration makes clear that the interpretative approach to questions of non-refoulement, such as the severity of the harm, the real risk of its occurrence, and the nature of protection from harm, are likely to be highly similar, if not identical, to those spelt out for the Refugee Convention. In other words, most of the interpretative approach that we've just described in relation to concepts like well-founded fear, real risk, severity of harm for refugee law are likely to be similar in the way that they are approached for non-refoulement under human rights law. There are certain complexities here, though. Particularly in Europe, the European Court of Human Rights jurisprudence has, for example, held that where the, quotes, predominant cause of the harm feared under non-refoulement rules is poverty or the state's lack of resources to deal with a naturally occurring phenomenon, then a higher severity threshold of, quotes, very exceptional circumstances applies, as opposed to when it's just the direct and indirect action of human state or non-state actors. So in other words, in the European context, if the source of harm is the direct or indirect actions of human beings, be they state or non-state actors, then the normal approach to non-refoulement applies, whether there's a real risk and so on. But if the predominant cause of the harm is poverty or state's lack of resources to deal with a naturally occurring phenomenon, then the European Court says that this higher severity threshold of very exceptional circumstances needs to be applied. What's interesting is that as yet, the European Court has not applied this higher threshold to any case involving refoulement to a country where disasters play into conditions of risk on the ground. By contrast, it has frequently applied this higher threshold to a line of cases involving challenges to removal on medical grounds. In other words, where somebody in a host country resists removal on the basis that they have a medical condition that would deteriorate significantly if they were removed. So the fact that the European Court hasn't in fact yet applied this higher threshold to cases involving disaster risk may reflect a recognition on the court's part of the distinct nature of disaster contexts, in which the risks of harm are so often shaped not just by, if you like, natural illness, but by human elements, as we saw earlier, in shaping exposure and vulnerability to natural hazards. Moreover, it has to be said that human rights treaty bodies in other regions don't seem to follow this European approach. But if it were applied to disaster contexts, it would raise questions about what counts as very exceptional circumstances in the disaster context. And our argument is that that very exceptional circumstance in the disaster context looks quite different from very exceptional circumstance in the medical case context. As a final point, a broader approach may in fact be possible under the regional refugee frameworks in Latin America and Africa that extend refugee status to people who are fleeing serious disturbances of public order. And in this regard, the declaration outlines that disasters can contribute to creating or exacerbating such disturbances, and also that such serious disturbances of public order often do occur in situations where disasters interact with and exacerbate or trigger armed conflict and generalized violence. But it's important to remember that the occurrence of a disaster for these definitions isn't enough, and that individual applicants will also have to demonstrate a risk of serious harm as a result of these circumstances in order to qualify as refugees under the expanded refugee definitions in the Latin American Cartagena Declaration or under the OAU African Refugee Convention. Next slide, please. So I hope this gives a good overview of the key principles and norms identified by the new RLI Declaration. It's been a real pleasure to have the opportunity to present some of our thinking on this issue to you here today, knowing that you represent such a broad range of civil society and legal organizations engaged on refugee law challenges in this area. We think that the real challenge in these cases is the factual context of disasters and climate change, which is one of particular complexity, as I hope I've been able to communicate this morning. Nonetheless, the key point is that the essential legal rules governing international protection remain unchanged. All that's needed is clarity on how they apply in these new factual contexts. I trust that this presentation has given at least a flavour of how the RLI experts who've been involved in this declaration believe this application plays out. Thank you very much for your attention. I greatly look forward to your comments and to your questions.